I think the legal problems have been solved. I think we have, in the interim at least, a political problem. How is government going to comply? Because now he must report to the police station, and an arrest must be effected in some way.
South Africa's Constitutional Court has ruled that former President Jacob Zuma is guilty of contempt of court, issuing a 15-month sentence on the former president. Joining me to discuss this matter is legal researcher at the Helen Suzman Foundation, Christopher Fisher. The foundation was an amicus curiae in this matter. Chris, welcome to the Centre for Risk Analysis.
Hi, David. Thank you for having me.
Chris, tell us, what are some of the high-level details of this judgment, and what is the significance of it?
Well, as you noted, it was a finding of contempt of court. The contempt related to a previous decision of the Constitutional Court that compelled Mr. Zuma to obey a subpoena issued by the State Capture Commission. Mr. Zuma was in breach of the Constitutional Court order, so a second approach to the court occurred, in which he was asked, the court was asked to declare him in contempt of the original order. So the mischief, as they say, in this case, was his breach of the Constitutional Court order that preceded this one. And the question of contempt was never really hotly debated. There was really no complex law involved, complex facts as well. He was in contempt of court. He didn't obey the order, didn't defend his disobedience. So the finding of contempt was not unsurprising. Where the debate began was sentencing. There was a range of sentences. The court's got a broad discretion to sentence in contempt matters, and that's where the HSF got involved. So the applicants in the matter were seeking a purely punitive order, which essentially means 2 years, which was essentially 2 years jail time. We thought that there would be a benefit to having a nuanced debate about an order that could at least try and force Mr. Zuma to testify. We didn't believe that it was as a result of his rights being breached in any case. We just thought that there was a moral value to his testimony that should have at least been debated before the court, and it was. The position that we put forward was that there should be a mandatory jail time with a further period that could be waived if he decided to testify. So the sentencing debate was really how much mandatory jail time would Mr. Zuma have suffered. That was the debate that the Helen Suzman Foundation was trying to put forward in front of the court. And ultimately, the court found that the public interest of defending the judiciary outweighed the public interest in Mr. Zuma's appearance at the State Capture Commission. So it was not an easy debate to have. We're glad that it was had, and the outcome certainly isn't antithetical to any important values that we held. So I suppose that's the high level view of what happened. There were further debates. There were details about Mr. Zuma's rights. I could go into those if you would like me to.
Enjoying this analysis? Click here to sign up for our 30-day free trial for more content from the CIA.
I'd like to discuss that further, and also could we unpack the minority judgment as well? And Mr. Zuma's team, specifically Jimmy Manyi, his spokesperson, has said that they're going to be studying the judgment and will also be looking at these minority judgments and trying to sow some doubt there as to that verdict. So what is the Helen Suzman Foundation's view on those minority judgments?
Well, perhaps the starting point is to see how the minority viewed the rights-based issues that flowed from its finding. So once you sentence someone to prison for contempt of court, several rights seem to be implicated. The rights to not be arbitrarily deprived of your freedom, and fair trial rights under the criminal law. The trouble with contempt proceedings is that they're hybrid in nature. There's the civil aspect of the underlying disobedience of the subpoena, but then there's the public harm of of disobeying the court itself, and that seems to that's a wrong worth criminalizing. So there's sort of a twofold character to contempt proceedings. Now, the question then is, how are the one's fair trial rights implicated by the criminal aspect of this? The majority thought that they were relevant but not directly implicated, to the extent that Mr. Zuma was not entitled to the full set of fair trial rights that you would in an ordinary criminal proceedings. They looked at section 12, which is arguably, which talks about the fact that no one should be arbitrarily deprived of their freedom. And from that right, they said that there is some sort of right that Mr. Zuma has to make fair representations. But the common cause facts in this case were that Mr. Zuma at every stage had turned his back on all opportunity to make his case. He didn't defend the merits of the contempt, the extent of the contempt, or the nature of the contempt. So the majority was satisfied that although that there is this criminal element to the contempt proceedings, they weren't implicated to such a fundamental extent that the protections already awarded to Mr. Zuma were inadequate. And they specifically noted a letter that was sent by the Chief Justice after the hearing, which asked Mr. Zuma to give submissions about his impending penalty if he were found guilty. So there was quite an effort on the part of the court to make sure that his freedom was not arbitrarily deprived in this case. So that's why the majority was comfortable with the purely punitive sentence. The fault line between the majority and the minority was that the minority saw the collapsing of the civil and the criminal elements as more fundamental. So the applicants in the case didn't even try and get Mr. Zuma to comply with the subpoena. They, I think, as most people looking at the facts of the situation, would have thought that it was pointless to even try. He was digging in his heels, he stuck to his guns, he was not going to talk to the State Capture Commission. So in the utter absence of an attempt to enforce the civil element of this case, the minority said that the fair trial rights are really implicated far more fundamentally than the majority thought. So they go on to point out that there is quite a bit of case law that gives courts options in this regard. Certainly doesn't force courts to put contemptors in jail. In fact, this is the first time it's happened. Both judgments are quite clear on the unprecedented nature of this. So the starting point for the minority was that fair trial rights are implicated more seriously than the majority said, and this is unprecedented. There are options here. So the remedy essentially crafted by the minority, or that they would have crafted, is they would have tried at least to have crafted a remedy that would have tried to compel Mr. Zuma to adhere to the civil element of the contempt. Because in their view, the only way you could redeem this collapsing of the criminal and the civil is to allow Mr. Zuma a chance to comply and a chance to enforce the underlying court order. Without those two redeeming features, the minority thought that a outright criminal sentence, outright punitive sentence, unfairly or unjustifiably limited the right to a fair trial and the right not to be arbitrarily deprived of freedom. So really the debate hinged on the nature of the proceedings. Were they criminal or were they civil, or were there a combination? And was Mr. Zuma afforded the right level of protection?
Chris, I wanted to ask you about the process going forward. Mr. Zuma obviously has to submit himself to the police at the Nkandla police station. Is there any risk that if he were not to do so, that he would be in further contempt? Do you think that there is a risk of that, of him not showing himself to the authorities?
Well, I think that the way forward from here is certainly, I think we're no longer facing a legal problem at this point. I think the legal problems have been solved. I think we have, in the interim at least, a political problem. How is government going to comply? Because now he must report to the police station. and an arrest must be effected in some way. There needs to be, I think, a political solution to that problem is probably the character of the next problem in this saga. I can't answer confidently about what the legal consequences would be for further contempt. It would seem to be absurd if a third application were made if he didn't present himself to the court. But that's purely from a common sense perspective. I can't speak authoritatively legally on that. In summary, I think we have a government now has to figure out how this order is properly instituted, I guess.
Chris Fisher, thank you very much for joining us on the CRA channel. I think this was a very significant moment for the rule of law and constitutional democracy in South Africa. My name is David Ansara. This is the Centre for Risk Analysis. Until next time, take care.